Counsel, did you file an attorney of record?
I did.
Good morning, Mr. Johnson.
Anyone,
How are you? Come on up. So this is it Lauderdale?
Lily.
Oh,
Page 8.
right. Good morning, Mr. Lee. Sir, you were charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 5th, 2025, the officer was conducting surveillance as part of a traffic crimes task force of motor vehicles racing westbound on Grand Parkway, and the officer observed the defendant's vehicle traveling in lane 2 and another vehicle in lane 1. The motor vehicle slowed down to approximately 30 miles per hour before launching at the same time in a competitive manner, accelerating to well over 110 to 125 miles per hour in an attempt to outpace each other. The motor vehicles raced 3 times, then pulled into a Buc-ee's. The officer observed the defendant, but was unable to locate the...
Okay, let's pause. This guy was already out on bond for felony evading, then gets caught street racing over 110 miles per hour. That's not just reckless, that's basically sprinting into court, wearing a neon arrest me sign. But here is what's wild. Instead of revoking the bond on the spot, the judge gives him a strict no driving condition with a warning so clear even saving a burning orphanage won't get him a pass. Now here is the real question: should bond be automatic in cases like this? Or is it time to tighten the rules for repeat offenders? Because at some point public safety has to come first. What do you think?
involved in the race.
So then it says also he picked up a felony evading. He was on bond for a felony evading and now he's picked up this case, a racing?
It looks like that's the case, Your Honor. He was on bond for the evading.
I'm taking away your privilege to drive. You are not allowed to drive, Mr. Lee. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what is going on in your life. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This is an affidavit that you're going to promise me that you're not going to drive. Do you understand? There's a burning building with 50 kids in it. I don't care. Do not drive. You mind filing those conditions as well, please? No driving.
No driving? Yes, Judge.
Have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Johnson. He will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, you pick up another case, I'm going to revoke it. And if I find that you're a danger to the public, I'm going to make it sky high. I will do everything in my power to protect my public at all costs. Do you understand? You want the same day as the felony?
Sunday is only fine.
Yeah. Okay. All right, guys. I'm going to have you sign a reset. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. All right. Thanks, guys.
The felony is all the way in June 2nd.
Mr. Lee, 2026, Your Honor. That's
Is it set for trial or something?
No, he was on that's a placeholder setting because it was a PTI.
What's going to happen with that? Is he still in the PTI?
It was, from my understanding, I don't know. I think it was some conditions he had to do and he's almost done with it. So I think he's close. I don't know.
So is that, do you know whether they're going to keep him in now? Do they know about this?
I'm sure they know, but
Does the felony court?
I'm not attorney on that.
You're not the lawyer.
No, but they.
Okay. So let's just do this. Let's just do it right. We'll do a 30-day reset. And then I don't know what's going to happen upstairs. We'll see. You just keep us in the loop. Okay. All right.
Thank you.
Good to see you.
Good to see you.
Next.
Wow. All prosecutors are out next week, huh? All you guys are gone next week?
Except for me.
Ah.
Yeah. But we have, I can tell you the schedule who will be sitting with me if you're so curious.
Who?
Okay, on Monday, Michael Hanover.
Okay. I know Michael.
On Tuesday, Whitney Raspberry.
Okay. She's been in here. I like her.
Wednesday, Amy Bolletino,
Okay,
Thursday, Scott Pope, and Friday, Stephen Harris.
I didn't see Scott Pope in years. You ready? Come up, Mr. Waters. So here's the deal. So your lawyer came in here twice. You weren't here. It's okay. I'm not going to ding you on it. My main concern is I don't want you out in the middle of the night just doing things that you're not supposed to be doing. And when we spoke to your lawyer, from what it appeared is, are you on a bus at that time?
I got my new apartment. I got all my paper right here, and we relocated all the way in A-Leaf right now. So the bus, it takes a long time to come. It don't come at the time that it say it'll come. So you know what I'm saying? Wherever I'm at, I'll be like, dang, I'll make it on.
Speak normally. Don't
Yes, sir. Yes, sir.
have to really just
Nah, 'cause I'm
speak normally,
just trying,
intelligently.
yes, sir. I'm just trying to show you, like, that I'm out here really trying. You know what I'm saying? I got my information.
No, you know what I'm saying? No,
I'm sorry.
just,
I'm sorry. I'm sorry. Good luck.
hey, speak.
This moment right here in the sleeper gem, the judge, in just handing down restrictions, Hayes giving real-life advice. Look at how Hayes pushing the defendant to learn a trade, not just grab a job, but build a career welding of CDL licenses. These are not just options, they're exits from the system. It's one of those rare scenes where the courtroom feels more like a life coaching seminar than a criminal hearing. Now be honest, if more judges talk like this, do you think it would actually help cut down on repeat cases, or is it just wishful thinking?
Have you sign a reset, put you on the same day for the felony so they don't have to keep coming going, all right? All right, come on, Mr. Waters. Thank you, Mr. Waters. Yeah, I guess go to 10:30, yeah. You speak English, sir?
Yes, sir.
Come on up.
I'm still waiting for my work.
Do you know if they're going to be here?
Yes, I will.
Did they know, what time? If you want to wait, we can wait a little bit. I'm fine with that. Yeah, just let them take a seat. We'll come back, please. Ms. Benedict, you were charged with assault causing bodily injury. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On January 2nd, 2025, the officer made contact with the complainant, a Walmart asset protection employee, who stated he was contacted by other staff members about the defendant attempting to enter the employee-only section of the store. The complainant confronted the defendant, and the defendant presented manifestly under the influence of an intoxicant, and the defendant was asked to leave. The defendant refused, and the complainant blocked the defendant's entry into the employees-only section, and the defendant then punched the complainant 4 times in the chest with a closed fist, causing pain.
All right. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. No more PR bonds. Do you understand, ma'am? Where was this?
It was at a Walmart, Your Honor.
Okay, you are not allowed to go to any Walmarts. Do you understand that is also a condition of your bond? If you violate any of these conditions, you pick up a new case, I will revoke your bond, put you in jail, and are you employed at this time?
No, I have a job interview tomorrow.
Did you want to apply for an appointed lawyer?
Yes.
Okay. I already have an application on file. So what I'm going to have you do is I'm going to have you go to Victoria Center Reset. I'm going to have you get with Fleischer for your bond conventions. We'll have you take a seat in the jury box while we find your lawyer. Okay? Please,
Judge, no contact with the complainant is right this way.
please, and no weapons.
Yes, Judge.
Is it bourgeois? Ferris? Bourgeois. Come on up, ma'am. Was that right? Bourgeois?
Yes, sir.
Ma'am, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 2nd, 2025, officers were dispatched to a trespasser call at a McDonald's in Harris County, Texas. The complainant, the manager of the McDonald's, stated the defendant had been asked to leave several times before and refused to do so. The complainant stated she and her staff observed the defendant in the parking lot checking car door handles, and the defendant stated to the officer that they had not asked her to leave the location and that she had not done anything wrong. That's what the defendant stated, but yeah,
So-
the complainant stated she had been asked to leave, and the defendant stated she was not. But the defendant did say to the officers that she was asked to leave several times, and she refused to do so
At this McDonald's.
at the McDonald's stop.
All right. Ma'am, I'm going to find that there's probable cause to go forward with your case. Do not go back to this McDonald's, please. I'm making that a condition of your bond. Do not pick up any new cases. You were able to get out because we gave you a free bond. If you pick up a new case, you violate conditions. I'm going to revoke the bond. I'm going to make it high. If you don't have anyone to make that bond, you'll be stuck like Chuck in there. So consider this when you're out there. Please don't pick up any new cases. Be nice.
Your Honor,
Tell me, do you have the ability to hire a lawyer?
I don't.
Okay. Would you like us to appoint you a lawyer?
Yes, sir.
I need you to fill out an application for me, Ms. Bourgeois, and then I'll take a look, and assuming you qualify, I'll provide you a lawyer today, okay? Do you mind, Deputy Brown, giving her an application, please? All right. I'm gonna have you, we'll give you an application, we'll have you sign a reset, and then I'll have you take a seat in the jury box.
Thank you, Your Honor.
Yes, ma'am. So can you file those conditions?
Returning to McDonald's?
Yes.
Yes, sir.
That particular,
That particular McDonald's? Yes, Judge.
do you have an arraignment?
No, Your Honor.
Okay. I'm trying to get through the arraignments first, so. Is this Trey Carter?
Yes, sir.
Mr. Carter, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 2nd, 2025, the officer observed the defendant's vehicle traveling at the 700 block of South Battleground Road, and the officer ran the vehicle's license plate, and the registration was expired as of 2021. A traffic stop was initiated, and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer smelled a strong odor of marijuana, and the officer could see marijuana debris laying on the center console. The defendant admitted that he does smoke marijuana, but that he did not smoke that day. The defendant advised he was in possession of a firearm inside the vehicle center armrest container directly to the right of the defendant, and the defendant does not have a license to carry. A PC search was conducted, and the officer found the handgun inside the center armrest container and a full blunt that contained a green leafy substance known to be marijuana based on training experience. The weight of the marijuana was 0.28 ounces.
Mr. Carter, I'm going to find that there's probable cause to go forward with the case. Did you run his license? See if he has a valid Texas driver.
All right, Your Honor.
Please.
Eligible, Your Honor.
Okay. You are not allowed to drive unless you have valid liability insurance in addition to a valid Texas driver license. I'm not putting any conditions on your bond now. Just be careful. Do not pick up any new cases. If you do, you become a danger to my community. I'm going to revoke your bond. I'm going to put you in jail. Do you understand? Do you, tell me, do you have the ability to hire a lawyer?
No, sir.
Sorry?
No, sir.
Okay. I'll have you fill out an application because I need you to fill one out. And assuming that you qualify, I'll provide you a lawyer today. Okay? Please.
Judge, was that state?
Let's talk about this assault inside a Walmart for punches to the chest. What started as a trespassing issue turned wild fast. The defendant was allegedly intoxicated, refused to leave, and then went full fight mode on an employee illegally. That's a one-way ticket to no PR bond and some heavy conditions. But here's something to think about: should every store security incident like this automatically go criminal? Or there room for a middle ground when it comes to minor scuffles? Is there a smarter way to de-escalate without clogging the courts? What do you think?